Now call 119862, State of Kansas versus Yesenia Sesma.
May it please the court. Meryl Carver-Almond, Capital Appellate Defender, on behalf of Ms. Sesmas, and Chief Justice Luker, may I please have 3 minutes rebuttal?
3 minutes is granted. Thank you.
Thank you. Your Honors, this is a case about the police lying to my client about her ability to consult with an attorney in a timely fashion, and using that lie in conjunction with her concerns about her family and her children, and in conjunction with her unfamiliarity with the English language, to continue questioning her after she had invoked her rights to remain silent, which led to her confession to the crimes at issue in this case. My client was arrested at her home in Dallas, Texas. The police served the search warrant at about 4 in the morning. She, her husband, and her children were taken from the house to the police station. About 8 hours later, the police sat down to interrogate her, and it became clear that they were interested in her because they believed that she was connected to the murder of a Wichita woman, Laura Abarca, and in the subsequent kidnapping of Miss Abarca's infant daughter. At that time, the police had already connected my client to the murder and kidnapping based on some cell phone messages between herself and Miss Abarca. They had cell phone tower tracking my client from Wichita to her home in Dallas, Texas. When they executed the search warrant, or about the time they executed the search warrant, they also discovered that a truck that was near Miss Abarca's apartment at the time that the child was kidnapped was at my client's house. Now they discovered the gun that they believed was used in the crime at my client's house, and they also thankfully discovered the child, who was alive and well, and my client had been passing the baby off as her own. She had recently suffered a miscarriage. So they sit down in this interrogation room, they ask a couple biographical questions to start with, and then they read my client her Miranda rights. And the first question out of her mouth is, how long is it going to take for me to get a lawyer? And they say inexplicably, that could be quite a while because we have to bring someone from Wichita.
Why do you say that's inexplicable?
Well,
Or a lot?
I don't want to be flippant in my response here, but last I checked, there were criminal defense attorneys in Texas that could have consulted with her. It's not Kansas-specific advice even. Miranda is pretty universal to all of us.
After that point, she invoked her right not to speak to the detectives, did she not? She signed the form and said no.
She did indeed.
So how was she coerced by that statement?
I think, and I think the state is actually kind of urging the argument that I hear Your Honor making. And I think our test for whether a statement is involuntary looks at the totality of the circumstances. I think we don't look at each little piece of this. We look at the whole piece of it. And even knowing, okay, it might take a little bit to get my lawyer, she did invoke her rights. Then I think you go to the next thing that she says.
And she started the conversation about her children.
She started the conversation about her children.
And did they give her any information that was untrue about her children?
They did not give her any information that was untrue.
Did they say, you're not going to see your kids unless you start talking to us, or anything of that nature?
They did not do that. However, they did, and I think the state cites to Thurber for the idea that when a suspect reinitiates a conversation, then that's kind of attenuation, so to speak. But here, and in Thurber, in fact, this court was very specific that the subject has to reinitiate conversation about the case itself.
Right. And she didn't do that. I understand your point about that she was just talking about her kids and her husband or boyfriend, whatever, and about the phone number that one child might or might not have for his dad in Wichita. And then she gets asked by the detective, so do you want to talk to us, or something like that, or...
She does.
And that's a reinitiation. I think that can be, I think we can make a fair argument that's a reinitiation of the interrogation, which is a Miranda problem. It's not a voluntariness problem, and you haven't made a Miranda claim.
I haven't made a Miranda claim. Unfortunately, I am... This is the argument that was made below, so this is the argument that I'm making on appeal. I agree that a Miranda claim could have been made here. That wasn't what was argued below.
But you agree with me that none's been made in this appeal?
I'm sorry, say that one more time.
You agree with me, none has been made in this appeal?
No.
You're strictly on voluntariness.
Strictly on
So in order
voluntariness.
for us to get to involuntary, your argument is we add together the statement made about the lawyer taking a while to get there before her invocation of her right to remain silent, to the truthful answers provided her about the whereabouts of her children after that invocation and before she decided she wanted to talk after all.
And I think you also have to look at, Your Honor, and I want to point out that as we're going through this, so they reinitiate with her. They say, so do you want to talk to us? She says, what is it you want to know? They bring the case back up. They bring a new Miranda form in for her to sign. Before she even signs it, before they even get the form out, she's already asking again, tell me about my husband. What's going on with my husband and kids? And the officer says, but first we're going to do this part, and goes through the Miranda rights. I think if you look at the conversation from start to finish, and it's just, a couple pages here.
So you're talking about after she says, I want to take that back or take it off, which I guess was interpreted by all to mean she wanted to do another form and say, yes, I will talk to you, that at that point there was more discussion of her kids or husband.
Of her kids and her husband.
Before she signed.
Yes, and I believe it creates a very clear implication. They weren't going to tell her more about her husband or children or how they were doing or allow her to communicate with them in any way until she spoke with them. And if you read the interrogation from start to finish, I believe that that is what it shows. And as far as a Miranda violation versus an involuntary confession, I think this court actually has case law that we've cited in the brief, namely Swindler and Aguirre, and I understand that Aguirre is a little more complex than that because the court said it was involuntary but actually found the Miranda violation. We have cases where this court has said, and rightly so, when a defendant invokes his or her rights and officers ignore that invocation and keep questioning, that can make the statement involuntary, and it does so here. I want to actually, kind of my plan for today was to talk sort of about the error in both issues and then take reversibility at the end because I think my reversibility arguments go to both issues. It's kind of the same argument as to both. And so I would like to maybe move on to the Doyle violation here. And it is absolutely crystal clear in Edwards. It is constitutionally impermissible for the state to elicit evidence at trial of an accused post-Miranda silence, period. And we get into some confusion. The state cites Reed. Reed was a test under the old prosecutorial misconduct standard where ill will of the prosecutor was part of the error analysis. And that's not the case now, as we know. And even in Reed, the Court of Appeals found that whether or not there was a Doyle violation was a close call. In this case, there was a Doyle violation. I don't even think that that's really up for serious debate. I think where my case, quite honestly, gets harder is when we start talking about the reversibility of that Doyle violation. And as far as that goes, I would urge the court to, first of all, remember that the state has the burden of proving beyond a reasonable doubt that the errors in this case did not affect the outcome of the trial.
But you did not raise a cumulative error claim?
I didn't raise a cumulative error claim.
So we look at those individual errors separate from each other?
Yes. Although, as I said, I think the argument as to both is kind of the same. But let's start with the involuntary statement. And I think when we're talking about what was harmful about that statement, I think we need to step back, first of all, beyond the four corners of the trial and look at what an attorney is supposed to do. Why do we have a right to an attorney in pretrial questioning anyway? And it's because an attorney at that point can be an advisor, can be a counselor. I think I will say 100 out of 100 defense attorneys would have walked into that interrogation room and said, don't talk to the police. And then, even if she said, well, I need to unburden my soul here. Okay, don't talk to the police right now. Let's wait and do it until we're at a time where maybe it can help you. Or you care about seeing your children again. Okay, I understand that. Let's try to negotiate here before you give away all of our negotiating power. To maybe see if we can get you some kind of sentence where you might eventually get to see your grandchildren. So I think if we just look at the four corners of the trial, that doesn't really take into account the full measure of the violation here. Looking at the trial itself, going into that on the reversibility analysis, I think you have to look at how important her credibility was here. She was saying essentially, yes, I did some of these things, but I didn't commit first-degree premeditated intentional murder. For that to land, the jury had to believe her. And her story, first of all, the jury knew that she had invoked her right to remain silent, which I think we have plenty of judicial precedent to show that that is prejudicial to a defendant. We have the jury hearing that she initially told the police a different story. She made up, at least the state was arguing that she made up this story about this Plainview man that she paid to come and kidnap the child and come in, and that she told him not to shoot Miss Abarca, but just to scare her and tie her up and rob her. And then you have the story about the accident. Well, which story is true there? Why should we believe you that it was an accident when you've already told this other story? So I think if you look at how that played into the trial, and yes, the state had a lot of evidence against her, and I think that makes her credibility all the more important. So for those reasons, because her statement was involuntary, because of the Doyle violation, and because I don't believe that the state will be able to show that those errors were harmless beyond a reasonable doubt, we would ask you to reverse Ms. Esmos's convictions and remand her case for a new trial without these constitutional violations. Thank you.
Thank you, counsel. Mr. Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, of course, this court reviews the factual findings for substantial competent evidence and the ultimate legal ruling de novo. This court looks at the totality of the circumstances to determine whether the defendant's statements were the product of her free and independent will. And on page 8 of my brief, I've set forth all of the relevant factors that this court has identified in that test. But really, in this case, what it comes down to from the defendant's perspective, I think, would be the factor focusing on the fairness of the investigators, of the detectives in conducting the questioning. She raises, I guess, 2 separate challenges. One based on her claim that this was a bait and switch by the detectives with respect to an attorney. And I would argue that that argument is simply inconsistent with the factual chronology here, as I believe Justice Beyer indicated in her questioning. From a factual standpoint, what happened here is that the discussion about an attorney came before she ever initialed the no box on the Miranda form. So there was that discussion. She then initials the no box, but then she immediately, without any more statements or questions from the detectives, it's the defendant who then asks questions about her children. The detectives simply tried to answer those questions and then eventually asked if the defendant was wanting to speak about the case. The defendant then gave this brief initial version of events. When the other detective, the Wichita detective, learned exactly what was happening, she immediately stopped the questioning, said that they had to leave the room. They, in fact, did start to leave the room.
So really, counsel, excuse me, you do kind of have 2 detectives here, and the one who's kind of a combination interpreter, interrogator, let's just say doesn't scrupulously adhere to Miranda when he brings up the investigation again after she's asked about her children. Does a good job of answering her questions about her children truthfully, but then, I guess, speaking in Spanish with her, so language that the other detective doesn't understand. Am I right about that factually?
Right.
Asks her if she wants to talk to them after all, even though they've got an invocation in their hand. Is that fair?
I think it is, because I think, as the district court noted later in the trial, I think that there was some confusion here. She initials the no box, but then she immediately is the one that starts asking them questions. And so I think
But
that
not about the subject of the investigation, about her own children and their whereabouts and welfare, right?
Right, and I think that's where the detective, what I would characterize what the interpreting detective was doing, was simply clarifying. whether the defendant was in fact wanting to continue speaking to the officers, and if so, whether that included a desire to speak about the case. And so I think obviously there is case law saying that when there's an ambiguity regarding whether a defendant has invoked, then that is appropriate for the
That's
interrogating
the problem.
officer.
The invocation couldn't have been clearer. No. I mean, the invocation itself was very clear. Then there was some subsequent discussion about unrelated matters or matters that were purely side effects of her arrest.
I think I would respectfully disagree that it was clear, because I think what the district court who had reviewed the video of the interrogation said was that this was something where you clearly had her actions and her statements were at odds with the box that she checked. That it appeared that
Videos in our record.
Yes, I believe so. Yes.
And help me understand why, just asking general questions about procedure, in essence, what's going to happen to my children, where are they, safety of the family, creates an ambiguity, because it's still not about the investigation.
Right. Well, I think just the way specifically that it happened, when you have somebody that's checked a box, but then immediately starts asking you questions about her children, I think that it's hard, in a way, it's somewhat hard to separate those things out, because from a realistic standpoint, clearly the process of the investigation is going to have, I guess, some effect on her children and how long they're going to be in custody. I think that this officer, and again, this is another situation where being in the room, I think probably the officers had a better ability to kind of weigh the situation than we might be able to in hindsight, to get a sense of, is this defendant in fact wanting to speak to us now? And I think the most important...
Counsel, may I interrupt you for just 1 second before you continue?
Of course.
You said the video's in the record, and obviously we can watch that ourselves, and I assume you've watched it. How does in the room work? This is a question that goes well beyond this case, but one that is bothersome to me. When we can watch a video at the appellate level, does that change the way our standards of review should work? When we can watch the same video that the trial court watched, the trial court wasn't in the room either.
Right, but I think the trial court still has the added advantage of having then seen the witnesses and being able to see them in person.
There was only the one witness, right, at the Jackson v. Deno?
Right, but just in general, going beyond this case, I think that the video itself, obviously, yes, you can watch it as clearly as the trial judge can, but I think the trial judge has the added benefit of then being able to see the live witnesses at the suppression hearing, which obviously helps with credibility determinations. And so when you combine those two things, I think it's still appropriate on the appellate level to give significant deference to the factual findings and any credibility determinations that the district court makes.
So we should, in essence, just accept the trial court's determination that it was ambiguous and move forward without any review of that?
I don't think you should just have to blindly accept it, but I do think it needs to be deferential as far as, again, the factual findings are reviewed for substantial competent evidence. So clearly, if a court makes a finding that there's absolutely no support for in the record, then this court would still be able to review that and disagree with the district court. But I just think that it needs to still maintain deferential review on an issue such as that. But I think what I want to circle back to the most is...
Counsel, let me
Sure.
jump in here while we're still on this point. I'm worried that your argument is trying to undercut the Thurber case, because Thurber was, as counsel said in the first argument, was very specific about what reinitiation of the questioning means, and it has to mean that it's the person being interviewed that has to show show the willingness to talk about the investigation. And I'm afraid that when you have a factual circumstance that says she invokes, you're not supposed to ask any more questions of her. She wants to know where her kids are, which is not related to the investigation. I don't think you can tag those two things together. She wants to know where her kids are. She wants to know where her kids are, which is not related to the investigation. I don't think you can tag those two things together. She wants to know where her kids are. She wants to know where her kids are, which is not related to the investigation. I don't think you can tag those two things together. She wants to know where her kids are. 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 She wants to know where her And then the police officers get to ask the next question, which is, now that we've told you about something unrelated to the investigation, are you now willing to talk about the investigation? That's contrary to Thurber. And Thurber was based on pretty solid, I think, I wrote it, but I mean, pretty solid U.S. Supreme Court opinions. And so how do you reconcile where you are in this argument with the case law as it exists today?
Well, I think we'd be in a different situation in this case if, after the discussion about her children, if the detectives had just started questioning her substantively about this case, and then she had simply agreed and said, all right, now I'm going to go along with this questioning. But that's not what happened. What he did was to ask, on the heels of her, essentially keeping them in the room. She had checked this box, and had she not said anything else at that point, the officers would have left the room. I think that's obvious by the fact that when Detective Tennyson found out the translation, she immediately did get up to leave the room. And so we have a situation where the defendant, by her actions, has kept the detectives in the room. And then after asking these questions, and I would note that in their responses, the police did nothing coercive here. This was not a situation where they linked her willingness to speak with the status of the children. It's not as if they said, well, if you speak to us, we're going to let you see your kids, but if you don't, you might not see them for a long time. They simply responded to the direct questions that she asked, and as counsel acknowledged, they didn't give any incorrect or false information. And then, rather than just asking a substantive question about the case, the detective simply said, okay, are you wanting to talk about this case now? And so then she said, yes. And then that's when the detectives left the room, got a new form, came back, and to be extra cautious, went over the second Miranda form from the beginning, and then ultimately, after she initialed that she wanted to speak, that's when the vast majority of the conversation ensued. So I think, while I agree that it's not the same as what we had in Thurber, I think that it's not quite as different perhaps as Your Honor is suggesting, because there was not a substantive question. It was just what I would again characterize as the detective trying to figure out, okay, we've had, she's initial no, but now she's kept us in the room, she's asking us a bunch of questions, and the detective simply tried to clarify whether she wanted to talk about the case at that point.
And
so
see, I don't think the officer gets to ask whether she's now willing to talk with us about the investigation after they talk about something unrelated, which has to do with her kids. That's what I think Thurber says. Now, granted, yeah, it could have been different. They could have walked in with a rolled up newspaper. I mean, they could have walked in with a car battery. They didn't do those. I mean, it could have been a lot worse.
Sure.
The question is, the point is whether they get to ask that question to try to overcome the box being checked that says, I want a lawyer.
And I think that's where the district court's opinion, and I think he made this statement more so in the context of the Doyle objection, but that's where the district court did find that this was not a situation, and obviously you're free to disagree with this, but that the district court found that this was not an unambiguous invocation. That in the district court's mind, yes, no doubt she checked the no box, but the district court's findings were that when you combined the check mark with her actions in continuing to question the officers about her children and then keeping the officers in the room, the district court flat out said this was a situation where you've essentially got her actions are in contrast to the check mark that she made on the box. And so to the extent that this court agrees with that, and I would argue it's correct, then it would be an ambiguous invocation. And in that point, it is appropriate for the officer to go ahead and ask that question to clarify whether she wants to now talk about the case.
Why don't you go ahead and move over to harmlessness, just because I don't want you to run out of time.
Sure.
And I think that's...
Would you,
Go ahead.
if I may, would you first address why this isn't a Doyle violation?
Right. Yeah, I think a couple things. First of all, tying back in with the argument I just made, if you agree with the district court that this was not ever an unambiguous invocation of Miranda, then there's no Doyle violation, because Doyle only occurs if there is a violation of the right to silence. I would also argue that even if it is characterized as her invoking, my argument would be it was still not a Doyle violation, because the purpose of Doyle is that if somebody has the right to silence, then that can't be used against them, and you cannot then argue that somebody failed to avail themselves of the first opportunity to speak. Well, here in this case, clearly what the prosecutor was doing, the whole purpose of that line of questioning of the prosecutor was to introduce the statement that she made. It was to show that she did in fact speak to police, and to go into extensive detail about what she did tell the officers at that first opportunity for her when she was given the chance to speak with officers. And so to suggest that the state was suggesting that she didn't avail herself of the opportunity to speak is inconsistent with the fact that the entire purpose of that line of questioning was to put on evidence about the statements that she gave. Now granted, and the prosecutor acknowledged this, he admitted at the bench conference that it was, I guess you could say, sloppy questioning on his part. I think maybe I don't know if he had simply forgotten that she initially checked the no box, or if maybe he just thought that the officer on the stand was aware that what he was really getting at was the fact that she did ultimately speak. But he acknowledged that it was poorly executed on his part. But I think when you look at the purpose of Doyle, which is to prevent the state from using somebody's invocation of the right to silence against them, here what the prosecutor did was actually put on extensive evidence showing that this defendant did speak, and that she gave these various statements that were inconsistent in many ways. And so we were the ones that were putting on all sorts of evidence about the statement. So again, admittedly, it was not the most artful manner of questioning by the prosecutor, but I don't think it would be fair to characterize it as a Doyle violation.
And I do want you to address Justice Biles' question, but I have a kind of a preliminary question before you get to that, which is, do you agree with counsel's argument that in examining the reversibility, we look beyond the trial and can look at whether or not her client in essence gave away bargaining power, or anything that would have happened before the trial, perhaps?
Well, I think that's a difficult path to go down. I really don't know how exactly, from a practical standpoint, that gets executed. I think when you're on appeal now, you have an appellate record, and I think that's essentially what this court should be bound by. A defendant is always free to make arguments at the trial court level that there might be things outside the context of the interview room itself that would factor into this, but unless they've made those, to just speculate about them after the fact and say, well, this could have been going on, or it might have influenced this, I think that's an awfully slippery slope to go down when it's an appellate's burden to designate a record showing error. And I don't know how the state or the state, whoever the appellee is in a certain case, I don't know how exactly you can respond to something like that. And I note also that it wasn't really raised in the brief itself. So.
And then how does the record show it was not reversible?
Yes. So even if you were to find that there was a problem with the initial portion of the interview before the detectives left and came back with the second Miranda form, I think now clearly the second statement was the same location, same detectives, the same general time frame. But there was this extenuating circumstance, which was the new form was given, read in its entirety. And then the other factor that this court has stressed is important is whether the initial error, if you want to phrase it that way, by the investigators was flagrant. And here our position simply is that it was not, that the officers, rightly or wrongly, were simply trying to clarify and understand whether she wanted to speak. They were not the ones that had initiated any discussion about her children. They were simply answering her questions, and I would argue that if the officers had simply plugged their ears and left the room, we'd be seeing the defendant argue that, well, the officers were coercive because they wouldn't speak to me about the status of my children. Then beyond that, what we have is that the second statement itself was, again, it was properly admitted. She gave a lot of incriminatory statements there. And I think the defendant's basic argument is, well, without her statement, in the defendant's position, what we don't have is evidence of premeditation. And I would argue that the record shows anything but. We had the firearm expert telling us that her story about this being an accidental shooting was simply not plausible because of the safety features on the gun that would prevent this from having accidentally fired. We have no evidence of a sudden quarrel. In all of those text messages and social media messages that the defendant and the victim exchanged, there was never any indication that this victim had any plans to give this child to the defendant. The defendant had made plans to, clearly had made plans to take this baby by any means necessary. She had asked the victim about security at her apartment complex. She showed up at a time that she knew that the victim was going to be alone because her mom and husband and boyfriend were back to work. She brought a real gun as opposed to the pellet gun that was found in her Dallas home, and she loaded that gun. And so clearly, if she was simply trying to go there and frighten the victim if necessary, there would have been no need to take a real loaded weapon, as she indicated that she was just trying to scare the victim. And then I would note that even after the fact, her actions show premeditation, as hours or a day or so after she had killed the victim, she then sent her a text message to further, I guess, cover her tracks. So I would argue that even if none of the defendant's statements came in, we have an ample amount of evidence of premeditation in this case.
Counsel, what was the timing of her miscarriage and her due date as compared to the victim's due date? Were the babies supposed to arrive at about the same time?
I don't remember in detail, and counsel might be able to clarify that. I think that they were at least in the same general time frame as what maybe was their due date, but I believe that the miscarriage had happened quite a time earlier. I don't think that
So
this
there was a fairly significant, what I'm getting at goes to premeditation.
Right, she had a lot of time to plan this.
Well, she was also not pregnant for a significant amount of time and continuing to fake that.
Right, to lie to her own family members, and then even after the baby was born, was already sending pictures and messages to friends and family members representing this to be her own child. So again, yes, I think it shows that clearly she went to that apartment knowing that she was going to do whatever it took to get this baby, and if that included having to kill the victim, then she had certainly made plans to do that. So even if this court finds that all of her statements should somehow be suppressed, there was still plenty of evidence in premeditation. For those reasons, if there are no further questions from the court, we would argue that the district court's rulings were correct and that the defendant's conviction should be affirmed.
Thank you, counsel.
Thank you.
May it please the court. I just heard Mr. Maloney ask this court partly to reject its role of de novo review of this case and to take the word of the officers that were in the room about what was happening here. So let's look at what the officer who was in the room said happened at Record 5, page 25. He says, well, after we read the first Miranda rights, she said she wanted to speak to an attorney. The officer that was in the room understood that she wanted to speak to an attorney. So I think that Mr. Maloney's arguments to that point just are not supported by the record. Second, we are arguing that the officers were also unfair here. They were also impeding her ability to communicate with the outside world. You can have an attorney, we don't know when. And in the meantime, you have all these questions about your children. Her children had been pulled from their home at 4 a.m. with the clothes they had on their backs. The police used explosive force to execute the search warrant. I think her concern about her children here is probably the most understandable thing about this case. And you have the police, and Mr. Maloney is right, and Justice Files is right. You know, they didn't pull in car batteries or newspaper, but there was a very strong indication in the transcript here that they were not going to answer her questions about her children. They were not going to keep answering those questions until she started talking to them. As to the Doyle violation, I just want to touch on this very quickly. Mr. Maloney says she didn't invoke. Well, if she didn't invoke, that doesn't make this better. And I don't want to accuse the officer of being a liar because I think his statement was very factually supported. But if she didn't invoke, then the officer told the jury she invoked still. And that's where the Doyle violation lies. So either way, that is very harmful to my client. Lastly, I want to talk a little bit about reversibility. To some extent, reversibility is always speculation. We're always trying to put ourselves in the shoes of the jury. And I perhaps it won't surprise you that I take issue with that sometimes, that we somehow think we can put ourselves in their shoes. So I don't think it is a wild flight of speculation here to say that if a defense attorney had walked into that room, he or she would have told her to be quiet. My 9-year-old child knows that, honestly. And also, Mr. Maloney is saying that our arguments, that we're talking about premeditation. I don't even know that we're talking about premeditation so much as intent, because I think that, as Justice Byer pointed out, she had miscarried the child, I believe a couple months before at least, and she had continued to pretend she was pregnant to friends and family. But that is all just as consistent with what I think, if you look at the record and you see at sentencing how her mental illness was brought up, that is perfectly consistent, I think, with her sort of delusion here that she was somehow going to adopt this child. And so I think the timing of it isn't so much an issue as her intent when she got there, whether she really was prepared to go in and was thinking about killing Miss Abarca before she walked into that apartment, or whether when she got there, things spiraled and it happened as a result of a tragic accident. For those reasons, as well as the reasons that I've argued already, we would ask this court to reverse and remand Ms. Esmas's case for a new trial. Thank you, Your Honors.
Thank you. Thank you to both counsel for your arguments. We will now take this case under advisement.